All right, good afternoon, everybody, and welcome to our webinar on what employers need to know about New Jersey's pay equity law. I'm just going to give a minute for anybody else who's still logging in to get in. All right, I think that should be enough time for everybody computers to have loaded. The materials are being shared, so you can download the PowerPoint presentation, which we're going to be going through. So the New Jersey's pay equity law is known as the Diane B. Allen Equal Pay Act. It is arguably the broadest pay equity law in the nation. It is not just gender equity, but it applies to all protected categories in New Jersey, and it applies to all employers that have an employee, one or more employees working in New Jersey. Now, as far as New Jersey's protected categories, I said there's over 20 of them. New Jersey protects everything from race, creed, color, national origin, ancestry, age, marital status, to civil union status, military service, gender identity and expression, and refusal to submit to a genetic test. So it's very broad, this law, and it potentially could be problematic for employers if they're not proactive in protecting themselves and making sure that their policies comply with the law. It's not a new law per se. It was actually an amendment to New Jersey's law against discrimination, but it did drastically expand New Jersey's existing pay equity laws. The law became effective on July 1st of this year. It was only signed into law on April 24th of this year. So basically, New Jersey gave employers 2 months to prepare and comply. It's very fast. Was not a lot of time for employers to get ready for it. By comparison, Massachusetts, which is also another very blue state, generally considered like New Jersey an employee-friendly state, passed similar legislation in 2016, which became effective in 2018. So Massachusetts gave 2 years for employers to prepare for a new law. New Jersey gave us 2 months. Now, the law requires equal compensation for substantially similar work. That is a significant change from the pay equity concept. Usually it's equal pay for equal work, but New Jersey went a little further. Does not give much guidance on what substantially similar work is. There is some language in the statute which helps clarify that, which I'll get to in a moment. It expanded the statute of limitations from 2 years to 6 years. Each paycheck is deemed a separate violation under the Act. And significant comparisons of wage rates are based upon the wage rates at all of an employer's operations or facilities. So a business that's in New Jersey that has employees in New York City, you have to compare the New Jersey's pay with the New York City pay. And unless you can establish a bona fide reason, if any protected category is implicated, they have to be paid the same if they're performing substantially similar work. To comply with the law, the statute specifically provided that you cannot reduce the compensation of the higher paid employee to comply with the law. Not a lot of employers have been focused on this law, but the ones that did, some of them were asked, well, can we just equalize the payments out? The answer to that is no. The lower paid employee has to get a pay raise to match the higher paid employee's salary. Now, substantially similar work, as I said, it's not that clear. The statute does describe it as substantially similar when viewing a composite of the skill, effort, and responsibilities. It's not much more clarity with that, but there will probably have to be some litigation, and the court's probably going to have to weigh in what substantially similar is. The big factor in this law is a pay differential between protected categories is essentially presumed to be discriminatory. And the employers have to justify a pay differential. And there's only 3 ways employers can do that. First one is a seniority system. The second one is a merit-based system. So that's typically going to be more involved in your unions. Now, for private employers, private employers are going to have to show bona fide factors. And to meet that portion of the statute, to show that a pay differential for substantially similar positions is not discriminatory, the employer is going to have to show that the differential is based upon legitimate factors other than protected class. The statute specifically identifies 4 of them and only 4 of them. And those are training, education, experience, and the quantity or quality of production. Employer will also need to show that the factors are not based on and do not perpetuate pay inequality, that each factor is applied reasonably, that 1 or more of the factors account for the entire wage differential, and the factors are job related with respect to the position and based upon legitimate business necessity. Now, the statute specifically says that it's not a business necessity if alternative business practices would have served the same purpose without producing a wage differential. Significantly, an employee's prior salary is not a bona fide factor under the law. A lot of pay equity laws prohibit salary history inquiries on the theory that they perpetuate pay inequality. New Jersey does not prohibit it, but there is no legitimate reason for a business to be asking about an applicant's pay history anymore. You can still ask about pay expectations, but pay expectations is not a bona fide factor either. It's only training, education, experience, and the quantity or quality of production. The statute, like most employment laws have, has robust anti-retaliation provisions. It prohibits employers from retaliating against an employee for engaging in a protected activity. The protected activities include opposing a practice that violates the act, seeking legal advice about an employee's rights under the act, sharing information with legal counsel, sharing information with the government, filing a complaint under the act, testifying or assisting another individual in the proceeding under the act, or aiding or encouraging any person to exercise their rights under the act. Significant thing about retaliation claims is they typically only require a good faith basis. In other words, the employee does not have to be right that there was a violation of the law. They just had to have a good faith belief that there was a violation in order to get any of the protections. Now, the penalties. Now, this is why employers should be very proactive in addressing these. An employee, if there's a violation of the act, will be entitled to compensatory damages, which are actual damages, interest, attorney's fees, and there is a non-discretionary treble damages award. So that means the compensatory damages get tripled. So if there was a $10,000 violation or $10,000 in damages, the employee plaintiff would be entitled to an award of $30,000 plus attorney's fees. Now, this is big because this is eventually going to look back 6 years. So that $10,000 difference per year over 6 years is a $60,000 differential. But that becomes $180,000 with the trebling plus attorney's fees. So this is going to be a type of case or a type of claim or an issue that's very attractive to the plaintiff's employment bar because there's going to be a big upside. I envision it'll be like the wage and hour cases where plaintiffs are filing on behalf of themselves and as a class action because there's a significant upside. So just to recap some of the changes from the prior law to the existing law, we went from equal or same work to substantially similar work. The law went from actual damages to treble damages. It used to be a 2-year statute of limitations. Now it's a 6-year statute of limitations. It used to be the employee's burden to show discrimination. Now the employee is simply going to have to show that someone in a different category than them is being paid more and they're performing substantially similar work. And it's going to be the employer's burden to then show that the legitimate bona fide factors applied to establish a permissible rate differential. The law used to compare the rates of pay in the same facility, in other words, the same facility where the plaintiff worked. Now you compare the rates of pay in all of the employer's facilities. I guess the good news for New Jersey employers is we're one of the higher states, higher costs of living states. So most jurisdictions or most other places, businesses will have offices, will not be much higher, but New York City is going to be higher. If you have a business that has an office in San Francisco, California, you're going to have to compare the rates for your New Jersey employees with the rates of the substantially similar jobs in those other states. So what should you do as an employer? Or what should you have done already? And if you haven't, what should you do as soon as possible, since the law is already in effect? First thing, the employers should be reviewing their pay rates for their current employees. Need to determine positions that are substantially similar, determine if there's any disparities among protected classes in those substantially similar positions, and then determine if they can be justified based upon education, experience, training, and the quality of production. And if not, then employers need to raise the salaries of the underpaid employee. Businesses should also be reviewing their hiring practices. Stop asking about salary history. There's no legitimate reason for it anymore, and it could promote pay inequality. It's not illegal per se to ask about salary history, but it's not a bona fide factor. So it can't be a reason that a business could justify paying an employee more. So businesses interviewing, hiring two employees, it's like a male and a female employee. John is asking for $90,000. Jane is asking for $80,000. If they have similar experience, qualifications, education, training, the fact that Jane was looking for less salary than John was is not a reason, or was making less at her prior job, is not a reason to pay Jane less than John, or vice versa, because New Jersey does recognize reverse discrimination. Now, an employer can still ask about pay expectations or requirements, but the compensation decision cannot be based upon that. It should be based upon an applicant's objective qualifications and not their negotiating ability or the expectations. Businesses should also review their salary review procedures. How do they give raises or determine raises each year? And really, the factors and the criteria should be objective criteria, something that if the DOL or the court has to come in, a business may be able to look at and say, employee A did this type of production. Employee A had this education or this many years of experience when compared to employee B. So that's why employee A is being paid more. Should also ensure that the raises are not promoting pay inequality. So if there's any questions, you could type them in the box. We're kind of a little faster than the last one we did. So, I'll stick around. If you have any questions, ask them. And then if they go for a few more minutes, because last session or last webinar, the questions went longer, I'll end the webinar so it's not recording anymore and hang out in the chat room. All right. I guess I did a good job. It looks like we don't have any questions. For any of the listeners, if you do have a question, feel free to reach out to me. You can call me from the information on the website, or you can go to my website, schedule a complimentary consultation if you want for 30 minutes. There's a scheduling link right on the website that you can use. And actually, I can share that with you right now. Find it. So, or you could use this link and schedule it. That'll take you to the online scheduling calendar. So thank you, everybody, for attending. I hope you enjoyed it and found it valuable. If your business is, if you have more than one employee and you're running a business, this is something you really should be aware of, because there are significant penalties for not complying. And it's a lot easier to try to comply in advance than to wait until an employee makes an issue of it, or the DOL or another governmental agency comes in seeking to audit you. So thank you again. I hope everybody has a good day.